All right, it is the top of the hour. Again, for everyone who's just been joining us, my name is Christina Boyd. I'm the Chief Growth Officer here with PRI. We really appreciate you taking the time out of your day to join us. Before we get started, I would like to first introduce to you today's panelists. Our first panelist will be Ed Clotton. He is the founder of PRI and a retired police lieutenant. Ed Clotton specializes in law enforcement, information management, and technology with extensive expertise in records, NIBRs, and CAD RMS technology. Ed is a trusted source for agencies needing records management, NIBRs, technology procurement, and auditing services. Ed is the CEO of our company, PRI, which provides training and consulting services to law enforcement agencies in 47 states. Our second panelist is Brian Cash. He is an instructor, a researcher, and a curriculum builder for PRI. Brian is also a retired veteran of law enforcement with over 27 years of service. Brian began his law enforcement career at the Leesburg Police Department in 1992 as a sworn officer. After 21 years of sworn service, Brian retired and moved to support services, where he managed both the records section and the property and evidence section. Brian is a subject matter expert in public records, NIBRs, and evidence management, and presents PRI training programs across the U.S. Julie Hubert is an additional panelist. She's also an instructor with PRI and is an administrative manager with the Lake Stevens Police Department in Washington. Julie began her career in 2004, and her expertise includes police records management, accreditation, policy and procedure, budget planning, public records disclosure. Julie served as the treasurer for the Washington State Law Enforcement Information and Records Association since 2008. And in 2019, she received their Lifetime Achievement Award. And our last panelist for today is Dan Zender. Dan is an instructor and a consultant and a retired captain from the for the Las Vegas Metropolitan Police Department. He is a subject matter expert in body-worn cameras and serves as a consultant for the Bureau of Justice Assistance Body-Worn Camera Pilot Implementation Program, grant training and technical assistance team managed by the CNA Corporation. Dan also serves as a body-worn camera grant peer reviewer for the Office of Justice Programs and is a member of the Bureau of Justice Assistance National Training and Technical Assistance Center's Body-Worn Camera Speakers Bureau. So this is a new event for us, and we are very excited to have the opportunity to support our audience and our customers. Several weeks ago, we asked you all to email your questions to us, and we received some excellent submissions from across the country. If we're not able to include your submission during this session, please know that our panel members will email you directly. Once we finish with opening remarks and answering the pre-submitted questions, we will open up the floor for additional questions. To submit those questions, please do so via the chat box, and also please indicate what state you are from when submitting your question. We encourage everyone to engage not only with our panel, but with our other attendees as well for their thoughts on a particular issue. Our goal is simply to create a community of support and information sharing. And for the next few minutes, Ed is going to provide some insights into the top 3 current issues in police records. Ed?
Yep. Thank you, Christina. Appreciate it. Welcome, everybody. This is Ed Clotton. Glad to have you here. So I see a lot of familiar names, so appreciate your time today. I think you'll find it interesting. I'm going to spend just a few minutes to prime the pump for today's discussion, talking about what we consistently see as the top 3 enduring issues in the field of law enforcement, records management, and technology. That's what we do, right? We live in this world. As a company, PRI serves agencies all across the country in about 47 different states. And so in every consulting engagement we participate in every training session that we participate in or conduct, we hear and have discussions centered around these consistent issues, these top 3 issues. And so they may not be new to you, to some of you, they may be new to others, but we as a company and as the individual instructors and consultants with us, we work very hard to help law enforcement agencies across the country work through these issues. So I'm going to get into them just for a couple of minutes, and then when I'm done, I'll turn it back over to Christina, and she'll get to the pre-submitted questions, and then we'll open the floor. So I was working with a department just a couple of weeks ago on a consulting project in California, as a police agency in California, and we were doing a records management audit for them. And they were having issues as an agency. They reached out for help because they were having issues with their crime stats, with the accuracy of their data, and they couldn't pinpoint why it was so inconsistent. And what we discovered was this number one issue, which is a lack of quality control in police records. And it's a systemic problem. It's a systemic issue in policing, wherein agencies don't understand the focal role of folks who work in police records, that being the review and approval of police records, including specifically incidents, accidents, supplements, arrests. At the center of that job in records management is ensuring that the department is producing accurate, error-free, and well-written information. And unfortunately, time and time again, we see departments that either find themselves in the news, kind of like the agencies you see on the screen there right now, for sometimes they're accused of having bad stats. They're accused of manipulating the crime data, when in fact it's just non-nefarious activity that's going on related to a lack of quality control in combination with an issue with the records management system. But whatever the source is, we have to get this profession to understand as a whole that until every police department embraces and understands the need for what's called a two-tier review process, which is standard. I don't mean to suggest nobody does it. Many agencies do this, but too many don't. That two-tier process being that police reports are first reviewed and approved by a sergeant, and then they get secondarily reviewed and approved or rejected if necessary by a person in records or other administrative person who serves as a second level reviewer for two purposes. One, to catch any mistakes that the sergeants might have missed in their review, and two, to ensure that the reports are compliant and accurate and error-free before they are released to the public and before they are shared out with your local judicial system, before they're shared out via public records requests, before they're shared really with anybody external to the agency. And it's a real issue. Time and time again, we don't see enough focus and emphasis being put on this in agencies. I've met many dozens upon dozens, quite literally, of agencies that don't have a two-tiered review process in place, and records personnel are not, or there really is no entity not taking on the role of quality control. Back in this agency I mentioned a couple of minutes ago in California, when we were doing the audit, as we always do, we sit down and we kind of meet with the records folks, and we'll do some job analysis and informal interviews and questions and lots of job observations as part of the audit. One of the records folks that I was speaking to told me, quote unquote, they don't pay us enough to check reports. And that was said in response to my question, what do you do when you check reports? Can you show me how you check police reports as part of your job? She said, no, I don't do that. They don't pay us enough. And, that is a person who needs to reframe the perspective and refocus what they're supposed to be doing. And I validated her concerns. I said, I agree. Most people who work in police records don't get paid enough for what they do. I totally agree with that. But on the same token, we still are being paid to do a job, a very important one, a very sort of mission critical job, to make sure that a government agency, a law enforcement agency, is producing information which is absent mistakes and compliant with public records law and compliant with NIBRs. So, you can look at some of those headlines. These are just different cases from around the country. We see them every year. We stay on top of the headlines that come about in the news. We hear from agencies that don't make their way in the news, but yet contact us because they're having these kinds of data accuracy issues. But quality control isn't just about crime stats. primarily centers around the importance of producing accurate crime data, but it also makes sure that the information within your agency's documentation isn't messed up and people aren't being attributed to crimes or arrests that they weren't arrested for. I've seen agencies, that incorrectly documented criminal charges on somebody who who was never arrested. We've seen persons who were missing being incorrectly labeled within the records management system and thus never being investigated. They never looked into the missing person's case because that person wasn't entered as missing. So status is really important. Disposition is really important. And quality control centers around all of those kinds of issues. The second issue, probably not too much to the surprise of a lot of you, centers around public records compliance. This is, in some states, some of you have Freedom of Information Act laws, Public Records Act laws, Sunshine laws. They all have a different name but serve the same purpose. And that is to make sure that government agencies are transparent to the degree that they can be according to the law. It's our job in law enforcement, particularly in those units which manage public records requests. Usually it's usually it's records. Sometimes it's the PIO office. But a failure to comply with public records law is also a systemic issue across the country. We see dozens and dozens and dozens of lawsuits come out in the news every year. The number one reason that I believe the number one reason for a lawsuit when they're filed against a law enforcement agency is for the inability of the agency to meet the timelines that are required to make those records available, to provide the requester the records within the legally mandated time periods. Some states have specific time periods, number of days to respond to the request that you received the request. And some other states also have another time response, a number of days that you have to provide the records. Some states allow extensions under exceptional circumstances for delays. Other states like Florida, they kind of rely on a reasonable factor, provide the records as is in a time frame that's reasonable. And when we see the laws that pertain to giving them out in a reasonable manner, there's two things to always remember with what's reasonable. One is if that record is immediately available to you, the employee at the agency, and therefore you can immediately provide it to the requester, that's what's reasonable. It's right then and there after you take a look at it, after you redact it. Immediate is reasonable. On the other hand, if that record is off-site or currently inaccessible or needs to go through a review and approval process and lots of redaction, maybe it's an extremely large request, that reasonableness factor is extended. And what the courts have looked at are three things. One, what is the size of the request? Two, what are the resources that the agency has? Do you have one person to handle public records requests, or do you have a whole team of folks? And then thirdly, what is the accessibility of those records? What's the accessibility of that information? Can it be pulled up very quickly and easily from a system, or do you have to go off-site and search for it in some archive case folders or warehouse, perhaps? So that's a really hot topic. It's an enduring issue, and I think we can do a better job. There is two things that I think are most important when it comes to achieving compliance with public records laws. Actually, three. One is obviously knowing what the state public records laws say about release of information. Two, maximizing available technology that is available for managing public records requests. And thirdly, having good business process, not having redundant, broken procedures, broken internal workflows that delay the process, and a lack of accountability for people getting their hands on those records internally as quickly as possible. And the last thing that we see as a really big issue is selection of bad CAD and RMS technology. This too continues to be a systemic issue in our profession. If you look at the bottom of the screen, you'll see some headlines that we have captured and thrown in here for the presentation. This agency lost $2 million on a failed technology project, a police department. Boston police officers say new records management system is a nightmare. That was back in 2017. I believe they've gotten a new system since then as a result of this. The Alaska Department of Public Safety spent nearly $28 million on a botched records project. And then, of course, this is probably the granddaddy of them all, a project known as REGION, the Regional Justice Information Network up in Portland, which was a project that was designed to connect 40 different law enforcement agencies' records management systems and CAD systems. And long story short, the project ended up being a complete failure. $12 million was scrapped. That's a lot of money. And the police department there in Portland last year was still asking yet for millions more to help cover the gaps because of all the agencies that pulled out of that consortium. The technology that they had picked in that particular project was not a good system. And over 40 agencies pulled out, saying they had had enough with the system. They had enough from the vendor. The frustrations had reached peak level, that they couldn't tolerate it anymore because it was impacting their ability to provide safety to the public. CAD calls for service were gone missing and that kind of thing. So it's a big issue. When police departments get these three things right, when a records operation runs like a well-oiled machine, workflows and business process are clean and direct and non-duplicitous, and technology is available. There's good, right technology. And things are running well, you can reduce typically the workload in a records management operation by upwards of 35%. And that's a good thing. I mean, most agencies today are shorthanded. What we find is that shorthandedness is largely due in part to what I was just referring to. A combination of bad business process, a combination of bad technology, sticking to old ways of doing records management and printing things out and still creating paper case folders and that kind of thing. And so we need to look at the processes behind the business of records management and see how we can improve things with our existing resources. And granted, you may be shorthanded, you may not have enough people, but it's always a combination of those two things. Increase in timeliness of police records and getting them out to the public and to partner agencies, the judicial system in a timely manner. The confidence in your data is important. Your crime stats are accurate. Lower risk, fewer lawsuits. Once you're able to meet the timelines of your public records requests and you are trained, your staff, your PIOs, your command staff, your agency counsel all understands what the current legal requirements are for the release and redaction of records. You certainly lower your risk in terms of facing a lawsuit. And ultimately, job satisfaction. When things run well, when employees work in an environment where things are smooth and you have a leadership team and an operational team in place that has clearly defined roles and functions and assignments and the right tools to do the job, good technology, people tend to come to work a lot more satisfied. So that's the opening precursor to what we envision the chat session being centered around. Christine, I'll turn it back over to you.
Thank you, Ed. All right, so we're going to jump into the questions, the pre-submitted questions that we have. So this first one comes from a Florida agency. The topic is confessions and public records exemptions. The requester said, please clarify what is and isn't a confession, and does an exemption only apply if the subject is placed under arrest? Also, are confessions leading to an arrest exempt, or only those post Miranda? And Brian, I will turn this question over to you.
Thank you, Christina. So this is a great question. So confessions are exempt from disclosure under Florida Chapter 119.07 2E. This exemption applies until such time as the case is finally adjudicated, dismissed, or there's some other final disposition. Note that this exemption does not go away upon discovery, unlike the exemption for criminal investigative information. This exemption applies across the board to both arrest reports and also incident or investigative reports. It is important to note also that it is the substance of the confession that is exempt, not necessarily the fact that there is a confession. The trick now becomes understanding the difference between a confession and an admission so we can identify what exactly is meant by substance. And this really applies regardless of which state you're in, because these are legal terms. The substance of a confession is the material parts of a statement made by a person who is charged with a crime in which that person acknowledges guilt and discloses the circumstances of the act or the share and participation which he or she had in it. On the other hand, an admission is simply a fact or circumstance from which guilt may be inferred. There's actually a 1933 Florida Supreme Court case, and yes, it's old but still valid, that acknowledging a subordinate fact not directly involving guilt is not a confession. Generally, the best way to identify a potential confession is to look for something like, after reading the Miranda warning, the defendant, and then what they said. And so from there, just determine if the person admits their guilt, then describes their role or participation in that particular crime to see if you have a confession that should be exempted and withheld. Back to you, Christina.
Thanks, Brian. That was a great question, and we really appreciate your insight on that. So the next question also comes from a Florida agency, and this topic is regarding inactive case status. The question is, should an inactive case, which is no longer being worked, be treated as closed for the purposes of Florida's active investigation exemptions? And I'm going to pass that question to Ed.
Yeah. Another great question. Florida's active criminal investigative exemption. Whether that applies should be determined by assessing whether you have, at this point in the investigation, an identifiable suspect and a reasonable good faith belief that there will be an arrest or prosecution in the near future. If those conditions aren't present, if you don't have a suspect that you're actively looking at, and you don't believe that there's going to be some arrests led an arrest in the near future, or even the sort of medium to longer term future, then the case should be treated as inactive, and you would no longer be able to apply the active investigative exemption. But I do want to emphasize, if your question, whoever asks this, if that question is related to using the status box in the RMS as guidance for applying that, that would not be good practice. You don't simply want to look at that box, and if the case status says inactive, then okay, we can release that information. That box may or may not be right, and case management is another issue where sometimes status and disposition is not updated properly. We see that all the time, where status and disposition in the system is not updated in a timely manner, or sometimes if ever. And so the best thing to do in this situation is to contact the assigned officer or assigned investigator and see where the case is, and then make your determination appropriately. Christina?
Thanks, Ed. Okay, so the next question is actually coming from Washington State. The question is, with the new laws about drug possession in Washington, we are wondering how this has impacted NIBR's drug offense reporting. Officers are still able to seize drugs in many situations, but only for destruction, no charges. And they are mostly not field or NIC testing the substances. Other times, we know that someone has drugs, but we have no PC to seize the drugs, and so we don't have enough information to report to NIBRs. What, if anything, are other agencies doing to help keep their NIBRs reporting as accurate as possible? And I'm going to pass this question to Julie.
Thanks, Christina. This is a great question, and one that's been on a lot of people's minds in Washington state. The Blake decision and other new legislation certainly has changed a lot for Washington law enforcement regarding what can and cannot be done about drugs statewide. Regardless, possession of drugs and other affected RCWs are still federally prohibited and need to be IBR reported. It's the whole purpose of the IBR program, so that drug-related crimes in Washington are reported the same as drug-related crimes in every other state. The reporting itself can be done a few different ways, and hopefully those discussions have already been happening in your departments, and that someone with IBR knowledge and training is part of those conversations. For most agencies, case reports are being taken with the applicable charges listed, those 35A and 35B IBR offense cases. The drugs should be listed as seized and taken for destruction if charges can't be filed. If the drugs are not field tested, they can be listed as suspected drug type. If your agency is taking a different approach and not taking a case report, that data would need to manually be entered into your RMS for that IBR upload, or can be manually entered into WASPIC's COPLINK program. And one step further with those laws, the law changes anyway, the agencies are tracking the required diversion attempts, mostly using FUR cards from what I have seen. I would strongly suggest also doing warning tickets in sector. Most agencies in Washington state use that program. So if a warning ticket is done, law enforcement from across the state would be able to see how many times diversion has been offered to people. Whereas if just using the FUR cards alone, it would be only available to those who use your RMS system. But as a reminder to agencies from Washington, while a lot has changed when it comes to drugs, remember that when possession and admission of use is properly documented in the police report, it's a firearm prohibitor. So that's a really useful tool, and we can also take that information, enter it into the NICS indices, and potentially tackle drugs from a firearm angle. So just keep that in mind when processing these. So thank you. Back to you, Christina.
Thanks, Julie. This next question will be for Dan. This question also comes from Florida. When a report is written and there are mentions of medical illnesses such as diabetes, depression, heart disease, etc., but a doctor did not say it, should that be taken as medical? Say, for example, the neighbor said it or relative indicated a diagnosis, but it's not from a medical professional. Dan?
Yeah, thanks, Christina. I offer to take this question because this is an area regarding HIPAA and law enforcement agencies we're seeing a lot more discussion of, especially with the advent of use of body cameras. But in this case, speaking specifically to a written record, in Florida, there's no specific exemption for medical info in Chapter 119. Medical records themselves, however, are protected under Chapter 395. And 395 makes medical and patient records confidential and exempt from disclosure without consent. Actual treatment and diagnosis records held by a law enforcement agency in Florida should remain confidential and not be disclosed. For example, a medical record obtained via a subpoena for a DUI crash with injuries remains confidential even though they become part of the investigation. And there's more on this in the 2019 Law Enforcement Guide in Section 17. Furthermore, Statute 395 3025 4E requires that patient records remain confidential even when disclosed to law enforcement for criminal purposes through a subpoena. The records must be sealed and must not be available to the public pursuant to 119.07 subparagraph 1 or any other statutes providing access to records, nor may they be available to the public as part of a public records investigation for or prosecution of disciplinary procedures made available to the public by the agency or an appropriate regulatory board. There's no case law or AG opinion that we're aware of in Florida that touches on specific information taken from the patient record and transcribed into a police report. However, we've learned that the general consensus among agencies in Florida is to redact medical information if it came from the attending physician or the actual patient file. And so I would encourage for the attendees, if you're outside of Florida and listening to this, really check with your general counsels, your legal advisors on the issue of HIPAA and the application to the records, especially these small incidences or examples that were in the question, because this can really trip an agency up. Christina?
Thanks, Dan. I believe this next question is also going to be kicked to you as well. The question is also coming from Florida. The question is there an exemption for body-worn video that is recorded in a school?
Well, so I could probably speak for an hour on this topic alone. The short answer is that there is no specific exemption for video recorded inside schools in Florida. However, I would encourage all our attendees, both Florida and outside Florida, to become familiar with HIPAA's cousin, FERPA, which is the Family Education Rights and Privacy Act. In that, like HIPAA, there's some rights that students have regarding privacy and information. Generally, it says that schools must have written permission from a parent or eligible student in order to release any information from a student's educational records. FERPA goes on to further say that schools can do that without consent, and it lists a following number of reasons it can do it, and two of those are important to the issue of law enforcement. They can be released to comply with a judicial order or lawfully issued subpoena, or they can be released without approval, without consent to state and local authorities within the juvenile justice system pursuant to your specific state law. And this issue of schools, body camera video, and privacy and release is big, mostly in K through 12. In my work with higher education, it's generally, they don't have a lot of complaints or use of force that reaches to the same level that patrol in a municipal or county law enforcement organization have. And inside the higher education system, there's a lot of checks and balances and who approves and how those videos are routed for approval that go beyond what you typically see in the bigger scenario of K through 12. And so I would say that in general, for everybody out there listening, there's a couple of things that you should think about to not put yourself in a position where you're scratching your head and trying to figure out what to do with releasing body camera video from school situations. Is ensure that you have a policy that's developed well inside your agency if you're the host agency for the school. If you're a separate entity for that K through 12 or university system, that you work with the prosecutor, general counsel, and confirm that your state laws are being followed regarding body cameras in those educational settings. You decide ahead of time from a records perspective who in the records system is going to release this video. If you are in a law enforcement agency, part of a university system, is it going to be released by the university? Is it going to be released by the university police department? That sort of thing. Educate parents and students about who and what you do with what your policy says about recording in the school environment, so that they have there's a misunderstanding from a lot of parents that everything's being recorded. And finally, develop MOUs between, if you're an independent police agency supporting a school, develop MOUs between yourself and the school district, especially when it comes to regards in these issues of records and release of those records to the public. Christina?
Thanks, Dan. That was excellent insight. Our next question I don't have the state indicator for this one, but it says when someone requests camera footage of a DUI and discovery was not made, would you provide the DUI footage to the requester, or keep it exempt until discovery is made, or really any footage with an arrested subject? And Ed, I'm going to pass this question on to you.
Yep, such a great question. Another fantastic question. I love that. Speaks to a topic which provides a lot of confusion, a lot of challenges to law enforcement across the country. So I'm going to give an answer that's going to help regardless of what state you're in. Okay, we've talked about this extensively internally, and I've had extensive discussions with many agencies about this, and over the last few years have come upon some good guidance. This is the old question about public records versus discovery. What has to be given out? What does not have to be given out? So such a great question. And the answer is this. In some jurisdictions, the local prosecutor's office, the district attorney's office, has a process in place with local police agencies wherein they direct requests for records as part of the discovery process to be directed to the arresting agency. So the prosecutor's officer says, if you need those records for discovery, go to the arresting agency and get them. In that case, you will likely, and you should confirm this, if you operate under that agreement, under that type of model in your jurisdiction, confirm with your prosecutor's office that you can in fact release everything as part of the discovery process. There may still be some exemptions to apply. There might be things that you have to take out based on your public records laws, but have that discussion with your prosecutor's office to determine, with them, what do they want us to provide when we get discovery requests. Now, the other model is where that does not happen, and there is no such agreement between the prosecutor's office and the local agencies. And what happens is attorneys come into the police department and sheriff's office and say to the records folks, I'm submitting a discovery request. That is a public records request in disguise. Okay? If they are coming directly to you and claiming that it's a discovery request, it's probably not a discovery request and should be handled exactly like you would normally handle any other public records requests following the laws in your state. A lot of attorneys, I know it's kind of big here in Florida, a lot of attorneys will try and get the records faster than they ordinarily could through the discovery process by utilizing the public records laws to get those records through a public records request from the arresting agency. And in that case, you're just going to follow what your state's public records laws indicate. Christina?
Thanks, Ed. Our next question is from Ohio. It reads, in regard to releasing full crash reports prior to citations being paid and the court case being over, currently we only release the initial report, meaning no narratives, no witness statements, no photos, until the citation is paid. Is this the correct way to handle the situation, or should everything be released right away? And Brian, I'm going to kick that question to you.
All right, thank you, Christina. So this one sounds to me a lot more like it's an agency policy or procedure rather than statute. Title 55, Section 5502.12 governs the use of motor vehicle accident reports, and it simply says the law enforcement agency that submitted a report shall furnish a copy of such report and associated documents to any person claiming an interest arising out of a motor vehicle accident, or to the person's attorney upon payment of a non-refundable fee of $4. I searched everywhere for attorney general opinions about this issue, but did not find anything about withholding narratives, statements, or photographs until a citation is paid. I also looked up the State Highway Patrol website to see if there was any information there, and there was no mention of this procedure. They only provided the cost for the request of the report, the photos, etc., along with the information that would be redacted. So I don't believe that you can hold that information hostage pending payment of their citation. Now, where you have a criminal traffic violation, then your CLEARS exemptions would apply as far as any investigative information is concerned. My recommendation would be to run this one past your agency's legal counsel. Christina?
Thanks, Brian. That was really great information. We do have a few additional submitted questions that we wanted to go over, but for the interest of time, I don't want us to run over. So I'm going to ask this last question that was pre-submitted, and I'm actually going to ask our attendees to give their thoughts and insights on this, and then we'll open up the floor to questions in the chat box. So this last question is for California agencies. For requests for 911 summary logs, is using an incident summary report a common practice among agencies? So I'm going to give everybody a few minutes in the chat box to provide their answers and their insight to this question.
Christina, while we're waiting, I'm anxious to cover question 9. I think that's a good question.
Sure.
And it's
Yeah.
short. It's short, so I can go over it if you want to.
Yeah, absolutely. While we're waiting for submissions to that question, let's cover question number 9. So that question is, what is the crime code to be used for habitual assault offense?
I believe this came from North Carolina. What is the crime code to be used for habitual assault offense? It depends. If someone is charged as a habitual offender, that particular offense would just be a 9DZ miscellaneous. But if the incident involves an actual assault, if the person committed an assault, then you're certainly going to report either a 13 aggravated assault or 13B simple assault, depending on the circumstances. Christina?
Thanks, Ed. And while you were chatting and providing an answer to that question, it looks like so Joe Sturgis is joining us, and he's saying it's not a common practice. Very few agencies create a summary. And it looks like Meredith, who's in North Carolina, she's saying all 911 call notes must be requested from the communications center. They do not release 911 call notes. So I appreciate Joe and Meredith, your insight as well. Looks like Jennifer is also saying we also don't manage our own 911 recordings, so they have an independent center as well. Okay, so we have about 15 minutes left in this session, and so we'll be now taking questions from the audience. As a friendly reminder, if we're not able to include your pre-submitted questions during the session or address all of the questions in the chat box, please know that a panel member will definitely be emailing you directly. To submit a question for this live session, please do so in the chat box and also indicate what state you're from. And again, we encourage everyone in the chat box to engage, whether it's either to ask a question or perhaps answer a question from a fellow attendee with your thoughts on the issue as well. So I will just give everybody a minute or so to submit their questions. Or perhaps while we're waiting, we can cover another question as well.
Christina, this is Dan Zender. There's a question in the question queue rather than the chat queue.
Oh, great. Okay, thanks, Dan. I am not seeing that question. Dan, if you've got it in front of you, do you want to go ahead and just ask it?
It looks like Brian answered it, Christina, and it moved it to the answered folder.
Oh, gotcha. Okay.
It's within questions. I don't know if everyone can see it there, though.
I don't know that I can see it.
I can certainly read it off if you'd
Yeah,
like.
go ahead.
The question that was asked there says, for Nibers fibers, is there a standard estimated value for license plates? In Florida, we have a variety of types of plates. And Brian answered that and said that he always uses $10.
Okay. Very good question. I have a question submission from Missouri regarding accident requests. It says, do you take all of the person's addresses and phone numbers out? We do only for DOBs and OLNs. Not sure who wants to take that question.
I'm currently looking that one up.
Oh, great. Okay. Well, Brian, while you're researching that one, I have another question from Arizona. It says, when photos and or video is requested, has there been issues with redacting or blurring juveniles? This came up recently in a department discussion.
I can address that. Not sure what the heart of the question is regarding issues, and whether or not juveniles can be redacted. I suppose maybe the question is about can juveniles be redacted from a video, and that's a depends answer. It depends on the juvenile's involvement in the video, and who's asking for the record. Is the juvenile themselves asking for the record? Is the juvenile's guardian or attorney or parent asking for the video? And what was the juvenile doing? Was it part of a criminal investigation? Was he just driving a car? So you have to assess the circumstances under which that juvenile is in the video, what was involved, and who was asking for the record, and then determine on whether or not it has to be blurred or redacted.
Thanks, Ed. Brian, are you still looking up that information regarding the accident request in Missouri, or should I go ahead and take another question?
I'm ready to answer it.
Yeah, go ahead.
All right. So generally, in Missouri, a person who was involved in an accident or whose property is involved in an accident is entitled to those records that might otherwise be closed, including the accident report. And so that information is necessary for them, obviously, to be able to do their insurance claims and such. However, there is a 2005 court case for Missouri when it comes to releasing traffic crash reports to the general public. And in that court decision, it says that license plates numbers, addresses, telephone numbers, and month and date of birth of the parties in vehicular incident reports are not subject to disclosure as open records, and you may redact such information. Back to you.
Thanks, Brian. Thanks for looking that up so fast. I did see a question in the chat from Florida regarding Narcan in a report, and is that considered a medical exemption?
No, there is no specific exemption listed in Chapter 119 when it comes to public records laws regarding Narcan. So if, however, there is other information in that record that would meet the threshold of being medical information, perhaps what the other diagnoses or what a person is being treated for, that kind of thing, then it might be subject to Chapter 395 and should be redacted. So it depends on the circumstances. And I see there's a great question, Christina, that came in. I want to answer for everybody. Let's see. It was from Georgia. How do you exceptionally clear, or when can you exceptionally clear a case? And the requirements for exceptionally clearing a case are standard across the country. And 4 conditions have to be met for you to be able to clear a case by exception. And that is 1, you have a suspect in the case who has been identified, and you have enough probable cause, you have enough information to be able to charge that person. Okay, so you have to have an identifiable suspect and enough to charge that person if you could. So that's number 1 and number 2. Number 3 is you have to know where the offender is. So if you could arrest them, you would. And then number 4, there is some reason beyond your control that prevents being able to make that arrest. The reasons can include things like the offender died, or he's in custody somewhere else and they won't extradite, or the prosecutor's office, prior to the arrest being made, the prosecutor's office said, we're going to decline charging that person, so you don't make an arrest. But make sure you read those conditions clearly in the NIBRS user manual. Christina?
Thanks, Ed. And thank you, Shanda, for submitting that question. I have a question from Alicia. She says, when do you use Florida Chapter 119 special service fee? Have other agencies had issues with the public being upset regarding the Florida Chapter 119 special service fee, or thinking fees are unreasonable, and how was that handled?
Christina, I can take that one.
Perfect, thank you.
All right, so Alicia, yes, people get upset anytime they have to pay for something. And so that's just something that we have to deal with. However, when it comes to applying that extensive use fee, the first DCA has upheld that it can be as little as 15 minutes to review and redact the report. However, my experience in Florida is that most law enforcement agencies and even city clerks and such generally give it 30 minutes. And so if it's going to take them longer than 30 minutes to review and redact the report, they'll apply that extensive use fee. Otherwise, they don't worry about it. Christina.
Thanks, Brian. And I'm going through the chat, and I'm not sure that we've missed any.
Let's do another good one. I want to get to one of the pre-submitted questions, if you don't mind, Christina. Number 10.
No, go right ahead. Yeah, we're on the same page.
So that one's for Brian. Do you want to give him those questions?
Sure. This is a 3-part question. So I think what I'll do is I'll ask each question individually, and then Brian provide your answer individually as well. So the first part of that question is a car dealership has 89 vehicles in a fenced-in lot, which the fence was cut through. The catalytic converters were stolen from each vehicle, damaging them the same. Is this considered trespassing, larceny of motor vehicle parts, and damage to property? Brian?
I'm going to answer this from the NIBRS perspective. Oh, can you guys hear me okay?
Yes.
All right, good. From the NIBRS perspective, this is a great question because it's not clear when you go into the user manual. And so the information I'm going to provide for pretty much all 3 parts of this is information that comes from the FBI trainers. And so for NIBRS purposes, you would report both the trespassing under 90J and the theft of the motor vehicle parts and accessories under 23F. Now, per the user manual, you should only report incidental damage, the cutting of the fence, if you deem the amount of the damage to be substantial. If you deem it to be substantial, then you would report it under offense code number 290 as destruction, damage, or vandalism.
Okay, perfect. Thank you. So the next piece to that question is another scenario where a subject went into Walmart and stole merchandise, but also they were banned from all Walmart properties prior to that incident. So is this considered larceny or trespassing?
So this is a tricky one because this can definitely be confusing when you're working between your state statutes and the NIBRS offenses. However, burglary in NIBRS is based on the illegal entry of a structure. So if a person has been trespassed previously, then they are no longer an invited guest. That means the trespass after warning would constitute an illegal entry, thus making the reportable NIBRS offense burglary, code number 220. Because the offense is burglary, you do not report the larceny to NIBRS since it is considered a lesser included offense to the burglary.
Thank you. And then lastly, when should a damage to property offense be submitted?
And so this is a great question, and I see we have in here in the chat from Sean asking the question also, what is considered substantial for damages? And NIBRS does answer this question for us. And so we're going to go to the definition, offense number 290, destruction, damage, vandalism of property. And that definition includes to willfully or maliciously destroy, damage, deface, or otherwise injure any public or private property without the consent of the owner or the person having custody or control of it. As a general rule, there must be substantial damage to the property. And so NIBRS manual goes on to say that this might be something like major structural damage or felony level vandalism or criminal mischief. If the damage is insignificant, like a broken window, then it should not be reported. And so for me, the guidance that I get coming out of that is if that damaged property, that criminal mischief or vandalism would be a felony in your state, then it would be appropriate to report it under NIBRS offense number 290. If it's a mere misdemeanor, not necessarily so. Back to you, Christina.
Thanks, Brian. And I'm monitoring the chat, and it looks like you guys are communicating back and forth, and I think that's awesome. I've got one more pre-submitted question that we can get to. This is from Florida, and it says we have a person who would like to inspect and view only records. The questions are, can this be done without prior redaction? If not, then does this agency charge the person for the time to inspect or redact any unnecessary or any necessary information? And then C, does this apply to open criminal cases? And Brian, I'll let you get that one as well.
All right, thank you. So part of this one, as far as the fees go for Florida and that extensive use fee, I think we've already answered. Once again, first DCA says if it's as little as 15 minutes that it can qualify for extensive use. Most Florida government bodies and agencies tend to use 30 minutes. I think it just gives them more of a comfort zone. Now, as far as providing the information and redacting and exempting, Chapter 119.07.1a grants every person the right to inspect and or copy a public record. However, when you drop down to paragraph D requires that if you assert an exemption, then the part of the record shall be redacted and the remainder, the non-exempt part, shall be provided. So this tells us that it's not only appropriate to identify exemptions and redact prior to disclosing the record, but that you're required to do so. And so we can look at that. Now, when we go to the criminal cases, this exemption does not apply to just open criminal cases. It can apply to any case, open or closed, provided there is confidential or exempt information in the report. For Florida, just keep in mind that the exemption for active criminal investigative information generally goes away once discovery is made. Otherwise, if reviewing and redacting the record meets your agency's determination of extended use, then go right ahead and charge them for just that inspection of the record. Back to you, Christina.
Thanks, Brian. So we are winding down. We are nearing the end of our allotted time, so we certainly want to be cognizant of everyone's time. Again, thank you for everyone for attending and submitting your questions and joining us today. Ed, I'm not sure if you've got another slide you wanted to navigate to. But I do see some activity in the chat box as well with additional questions. Perfect. So, with the topics that Ed brought up earlier today and some of these really great questions, we just wanted to let you know that, we're here to help. If you're familiar with PRI, if you've attended one of our many trainings, You've probably heard some of this before, but we provide training in a broad range of records management related topics. We encourage you to check out our training page. We provide also extensive consulting services. We help agencies transition to NIBRS. We help look at those efficiencies that Ed was discussing earlier today in your records units. And then also we provide consulting services if you're replacing your CAD and records management systems and want to make sure that you're buying that technology that's going to stand the test of time and be supportive to your agency. We can certainly help facilitate that process. So we encourage you to check out our training page, our consulting page, and certainly reach out to us if you have any questions about our additional services. We are more than happy to help. And we'll pull up some contact information as well. You can also email us directly. So our website, of course, is policerecordsmanagement.com. You can submit an email to info@policerecordsmanagement.com, or of course, call our office. Again, thank you for joining us. And we hope that you found today insightful and as informational as I certainly did.